Hey everyone, I'm Christian Ross. I'm an attorney with Campbell and Brannon, and I wanted to take this opportunity to go over something we're seeing a lot, and that is these contracts, these offers from iBuyers, and Open Doors and Knock, Zillow, and some of the others that are coming up. It seems to be a new one every day. And I just wanted to look at these contracts. I want to show you how I look at them, what your clients might be seeing, how they're being enticed, and then how to protect yourself against it, how to educate a client about it, how to really dig down and see if it's a good deal for them or if it's not. So let's take a look at the contract. These are two Zillow contracts, and you'll notice they're a basic standardized form, at least for 2021. This is what we're seeing. And what they'll do is add the state addendum at the end. And so we'll get that to the end. So we've got both a Georgia one, a Georgia addendum, and we have a Florida addendum. Let's look at Georgia first. You've got your seller, and both of these are when Zillow is acting as the buyer. And they have several companies or trusts set up where they may be different names, but we know that this one is Zillow. We've got an effective date, when it's signed, between buyer and seller. Let's scroll down. We've got our seller name, we've got the seller address. So that's going to be your client, potentially, the person that's calling you and asking you to review this contract with them. And you've got your buyer information. They're based out of Arizona. They're going to pick a closing agent. Now, these companies are going to work with one main closing agent. It could be a closing attorney in Georgia, or if it's in Florida, they actually have their own title services. So in both cases, it's probably a great idea for your seller to be represented separately, just to review the contract, go over things like this, but to also make sure that the closing is being done properly. They're going to identify the property. Now, one thing that I think is interesting is they tend not to add the legal description, which I think is an oversight on their part, but it's still an issue. So something to consider, making sure that that gets added in, or that we've at least identified the property correctly. If the seller is not trying to sell the whole property, if they're only selling one of the lots and not the other, we just want to be very specific about that. Scroll down, we've got our purchase price, $262,300, and let's just say it, they make that look like a very attractive number because that's what they put on page one. But what we'll see later on is that it's kind of smoke and mirrors a little bit. It's not the worst thing in the world, but it takes some digging to know what your real net number is. So let's keep going down. Actually, let's read it. The purchase price is not inclusive of the service credit to buyer defined below. Seller concessions for repairs and renovations, closing costs, prorations, and other fees and costs to be allocated to seller in connection with the purchase of the property. And that's what I'm talking about, is that later on they share with you what that service credit is. And we'll get that to in a bit. We've got our effective date, we've got a closing date. Now, I don't know why I'm seeing it this way, but they're putting these properties under contract and then delaying closing for 4 months. In this market, that's pretty unusual. We wouldn't see that very often, but that's what I'm seeing on all the contracts I've reviewed for them. This is what we see, and I don't know the reason for that, if maybe that's what the seller wants specifically, but I think it's interesting. This is the other thing that I don't love. Deposit, $1,000. Now, what you'll notice is that is hard-coded in there. They're not even giving their agents the ability to change that, potentially. They're just putting $1,000 down. And now we remember that purchase price was $262,000. Historically in Georgia, we might see 1 or 2% of the purchase price be put down as earnest money. This is $1,000, so this is less than 0.5%. So I would always educate my seller. Look, you're taking your house off the market for 4 months, and they're only putting $1,000 down. I don't know if that's enough. Now, it's the seller's choice to whether they want to fight with that or not, but it's just our reality. Keep going down. They talk about the homeowners association form, seller to fill in Exhibit C. And you'll notice in Exhibit C, they're using the Georgia Association of Realtors form in order to disclose the HOA fees. In other states like Florida, which we'll look at, they actually just include it in the addendum. Let's keep going. Purchase price and deposit, conditions of closing. This is all pretty standardized, nothing that I would alert you to. Examination of title and HOA documents. Very normal that they want clear title, and they have up until 5 days of buyer's receipt of the title report, title documents, HOA documents. As the case may be, buyers shall approve or object to such documents. So that's very similar to what we would see normally. Feasibility period, except otherwise herein, buyer shall have until blank on the date that is 15 days after the effective date. So let's highlight that right here. Now that's your due diligence period, or your free look. They have the ability to terminate for any reason, and they can have the property evaluated by contractors, estimators, inspectors, and other professionals who complete the necessary evaluations. This is no different than a due diligence period that we would see on a normal as-is contract. Now again, you'll notice that this is hard-coded in there, 15 days. And during the time that they're using this, we're seeing a lot of contracts where it's maybe 1 or 2 days or even 0. So this may not be very competitive when you cross-shop it with any other potential buyer. Conditions of the seller. Purchase as is, except as expressly stated in this agreement to make maximum extent permitted by law. Seller makes no other disclosures or representations that things are working, and they have the buyer initial this. So that's pretty standard what we'll see on these as is contracts. In fact, it does have some representations of warranty. So right after they say there are none, and then they say which ones there still are. So seller represents and warrants the seller holds legal title, has legal authority to enter into this agreement, and has disclosed to buyer and buyer's broker all material latent defects and any information concerning the property known to seller, excluding opinions of values which may materially affect the consideration. So I think that's interesting. They say if you haven't disclosed any material or latent defects, that the seller's in default and they can terminate. Title, conditions of title, basically need clear title, and they modify this later in the Georgia Addendum. So some of this stuff is going to apply and others will not. Title insurance, closing, very standard. Buyer's information, buyer shall pay all amounts required under this agreement in current funds. This is what the closing attorney is going to need to do. Prorations and charges, this is pretty standard. They're going to prorate real estate taxes and any HOA stuff. All parties agree to the buyer's deductions, service credit, repair concessions, and allocation of closing costs as shown in Schedule 1. So we'll get to that shortly. 5.4 holdback. This one, I had to read it a couple of times, but this is different. And I don't think I like it. So at closing, buyer has the right to hold back from seller and escrow up to $5,000 of the purchase price to serve as security for seller's satisfaction of the closing conditions provided for in Section 3 and Section 5. This is unilateral. Those closing conditions that holdback may secure include but are not limited to removing waste and other debris from the property, delivering the personal property to buyer in substantially the same condition, maintaining seller's reputations and warranties, or delivering possession of the property. So let's say this was a rental and the tenant didn't move out at closing. Well, the buyer can still close, hold back $5,000 unilaterally from the closing proceeds, and transfer title. And the seller then is on the hook, for that $5,000 if they can't cure that. And I believe they say it's 30 days. So in the event any portion of the holdback remains in escrow as of 30 days from closing, closing agent shall disperse such remaining amounts to seller. That's if it hasn't been reserved or satisfied, if it has been satisfied. And it says here, buyer has complete discretion. So, I haven't seen this done immorally or unethically, but I would worry that is, you could have a seller get taken advantage of or just become very upset after the fact if they didn't give this the proper weight. So the other scenario I would see is you agreed to sell the property and then the dishwasher breaks and the seller or the buyer says, hey, look, we're withholding $5,000 until you satisfy our objections to this. And they can kind of do that unilaterally. And I don't know if any of these scenarios would warrant that. It seems to be more about the representations and warranties and, delivering personal property in substantially the same condition. So it may impact a scenario like a washer dryer not working. So if the washer dryer was working and then at closing it isn't, the buyer can simply take $5,000 off the seller proceeds, hold it in escrow until it gets resolved, and then that money gets dispersed accordingly. I don't know how often this happens, but I just need to make sure that the seller is aware that it could happen. That's the big key. As long as you tell them to expect it, then they can only blame themselves or their dishwasher if something doesn't work. Let's keep going down. Buyer shall receive possession of the property at closing unless you specify otherwise. And so it's that, if that's that tenant scenario. Default, breach by seller. Let's look at this. And so far we've looked at what the price is, when's the closing, how much are they putting down, and what does the buyer have to do, what does the seller have to do. So now we get to default. What happens if they don't do it? What happens if the seller doesn't deliver clear title? What happens if the buyer doesn't come and close? So breach by seller. 6.1, if seller breaches its obligations under this agreement, buyer may 1. Terminate this agreement and receive the deposit, or 2. Waive such breach and close the purchase, or 3. Enforce this agreement by suit for specific performance, provided, however, buyer will not be entitled to pursue any action for specific performance against seller if seller is prevented from performing as a result of any governmental or regulatory authority. So basically they're saying, seller, you got to close because we otherwise have all these rights to come after you, either to close or to sue you to close, or we'll just take our money and run. And then breach by buyer, and again, that's actually pretty standard. So I don't have a problem with that. If we look at the buyer breach, if buyer breaches under this agreement, seller's sole and exclusive legal and equitable remedy will be to terminate this agreement, retain the deposit as liquidated damages. So they do not have any duty to the buyer or to the seller other than the earnest money of the $1,000. They talk about some of their affiliations. They talk about disclosures. Seller shall complete and deliver to buyer the disclosure, so that makes it a mandatory thing. So if, let's say, the seller chooses not to, well, I'm not going to fill one out, my attorney says not to, well, guess what? The buyer can keep that $5,000 as escrow until the seller actually complies. Insurance claim history. Seller shall deliver to buyer a written 5-year insurance claims history. I like that. That's actually kind of neat. It's a part of your disclosure. We could even use that in our own offers. Lead-based paint disclosure. We know that that's a federal requirement. Mold and radon. We talk about brokers. Seller hereby acknowledges that buyer has disclosed that certain affiliates of buyer and employees of buyer are licensed real estate agents. Miscellaneous, pretty straightforward. Who's the closing agent? The brokerage disclosures, they talk about whether commissions are going to be owed or not. And again, you'll have to look at the addendum or any special stipulations if we're changing that. We've got walkthrough conditions. 9.6, so a buyer may conduct a walkthrough of the property within 10 business days of the closing to ensure everything is up to snuff. If buyer elects to conduct such walkthrough, seller shall make all the utilities available. Again, that's pretty straightforward. They talk about the purpose. In addition to buyer's holdback rights as set forth above, if buyer discovers during walkthrough or any other time after the feasibility period that the property is not being maintained, is not as represented in seller's disclosure statements to buyer, if any, or seller has not complied with seller's representations, in each instance as determined by buyer in its reasonable discretion, buyer shall provide seller with written notice of such issues within 2 days of buyer's discovery, and seller shall have 2 more days to correct. If seller fails, buyer may terminate at any time, receive its money back. At buyer's request, the closing date will be reasonably adjusted to accommodate the notice. So that's a unilateral extension in the event during the walkthrough the buyer finds something they don't like. And they keep saying reasonable, reasonably adjusted. That's all in the eye of the beholder. What does reasonable mean? If buyer elects not to conduct a walkthrough, then all systems, items, and aspects of the property are deemed satisfactory, and buyer releases seller for all liability. That's a very interesting one. I don't hate it, but the seller needs to realize, look, these are their rights. They can extend closing unilaterally as long as they deem it reasonable. Assignment restricted. Seller's rights and obligations under this agreement shall not be assigned without the buyer's written consent. I think that's fine. The seller is not going to be assigning the contract to some other seller. This is, the seller. There's only one. Buyer may freely assign its rights and obligations under this agreement without notice. And that's okay. Zillow's not flipping these deals. They are, they're buying them for themselves. And they're going to set up LLCs or trusts or corporations to take title. And they need the right to differentiate what, they may not know which trust they're going to set it up in, so they're going to sign it later on. And that's a very standard thing. I wouldn't let my seller worry about that part. Keep going down. They can e-sign, no additional terms. This might be where you put information about commissions being paid or home warranties or a different type of earnest money deposit, something like that. We'll have everyone sign it. They'll talk about any of the special items, and then we get to the affiliations. So, these are all the parties that Zillow is affiliated with. They own some version of it. So Zillow Home Loans and Zillow Closing Services, these are basically title companies in other states. Keep going down. Georgia Addendum to Real Estate Purchase Agreement. Now, I'm going to skip to our Florida contract. This is the same contract, exact same. And we just have a different purchase price. I mean, what you'll notice, this is the exact same thing, right? So we are going to skip all the way. We'll get to the signatures. And on this one, you'll notice the buyer has an agent, obviously, but so does the seller. On the other deal, there was no listing agent, but on this one there was. We've got our exhibits. We've got our affiliated business disclosure, and then the Florida Addendum to Real Estate Purchase Agreement. And the Georgia Addendum to Real Estate Purchase Agreement. You may notice this up at the top. It is page 19 and page 19 of 25. So this is where it starts to get interesting, in my opinion. So if we look at Georgia specifically, they're going to restate the property, the form of the deed. Now, the reason why they do this part is that every state potentially has a different type of deed that would be used. And in this case, we'll find that Georgia, we're more used to a limited warranty deed. That's just kind of the standard practice. And in Florida, you'll see a warranty deed. So it'd be like a general warranty deed. So, that's fine. It's the buyer, you're the seller, so that's not a problem whatsoever. We've got our escrow agents. We've got and on this case, there is no escrow agent. They basically have it done separately. So we'll keep looking at Georgia, closing requirements, an affidavit of seller's residence regarding Georgia withholding tax. Obviously, that's a Georgia-specific thing. If your state has a withholding tax, like Georgia does, then you'll have this included in there. And if in Florida, there is no state income tax, so you're not going to have a form like this. Disclosures, they are specifying they want the seller to fill out a GAR, Community Association Fees, Disclosures, and Related Issues form. So the seller will provide buyer with the following disclosure within 5 days of the effective date. So that's a very Georgia-specific thing. And then everyone signs it. Pretty straightforward on the Georgia side. Let's look at Florida. Florida's a little bit more complex. It's a couple more pages. There's a permits disclosure. And a lot of this is, again, this is Florida-specific laws and traditions. So we've got permit disclosures about any open permits, knowledge of items that were supposed to be permitted but were not, Flood zones are a major thing in Florida. Obviously, it's a national requirement to have flood insurance if you have a mortgage, but it's just more of an issue in Florida because of the terrain in Florida. I grew up in Southwest Florida, and almost everyone has flood insurance because everyone is in the special flood hazard area. There's a energy brochure, and this is a Florida statute right there, so they're referencing any Florida requirements. Foreign Investment and Real Estate Property Tax Act, FIRPTA. Now, the contract already has FIRPTA disclosures in it. So if I was Zillow, I would probably remove it from this addendum, but they've got it anyways. I think what they've realized is maybe Florida has more foreigners that are selling real property than other states might. So maybe this is just, hey, this is more of an issue in Florida than it is in Georgia, even though they would both still apply. Maybe they're just trying to restate it. We've got seller disclosure. This is Florida law. Seller knows of no facts materially affecting the value of the property. And that's the same in Georgia, but they're restating what the Florida law is. Then we've got property disclosures, homeowners association form. They actually include the form in the addendum, and they fill it all out. And they've got to complete the information here, and then it gets, I think it got initialed or signed down here at the bottom. Association approval, if association approval is required. So in Florida, Southwest Florida, where I grew up, you will see where the condo or the HOA has to approve that buyer. They're going to look at their finances, and they're going to look at criminal history reports. Keep going down. Coastal construction control line, very Florida specific thing. Defective drywall, that's also something during the time Florida was experiencing building material shortages. Some homes were built or renovated using drywall imported from China. I'm sure that affects other states as well, but they've highlighted it on this form. Seller knowledge, again, they have to disclose the drywall. Inspections. Neither box is checked. Let's keep going. Housing for older persons. Is this, a 55 and older community or a 62 and older community? We've got the improvements for energy efficiency, renewable energy, and wind resistance. And then you've got signatures. I think it's kind of interesting that those are the items that Zillow has included on their addendum, because I think there's a lot of room for improvement, in my opinion. There's a lot of things in Florida that are not being addressed in the addendum, such as document stamp taxes and who's paying for title insurance, although it does say it elsewhere, but Florida traditions are very different from what they have on these contracts. So this could all change. I mean, any day these can change. So this is, again, I'm doing this in August of 2021. Now here's the part that I think is hard to understand. So, in top of my mind, the things that I think are very weird, the way they did this contract, to be kind, is the $5,000 holdback, making it unilateral, and then the right of the buyer to extend closing if they're not satisfied with the repairs or the conditions of the property, unilaterally again. Those things are pretty strange, but this one takes the cake for me. You remember that purchase price on page 1 of 262.3. So service credit to buyer, $12,000, $12,853. Now let's look at Florida. Florida's going to do the same thing. Again, you've got your purchase price, and then you've got the service credit to buyer, $62.34. Now I don't know how they come up with this number necessarily, but it seems to be some version of commissions, just some sort of convenience fee. And maybe when they sell these deals to the seller, they tell them about this first. They say, hey, look, we're going to offer you $262.3. If you got that in the market, you'd be paying $20,000 in commissions. Maybe this is a better deal for you, but you're still going to pay something. Maybe that's what they're doing. But then they add their seller concessions, and they come up with the actual offer. So there's your actual number. That's your net. Obviously, you might still have mortgages or delinquent taxes or things like that. But then you have your cash offer. The cash offer is before closing costs, prorations, fees like HOA, taxes, expenses, and payments. An estimate of the seller net proceeds will be set forth on a settlement statement provided to you. And then they specify who's responsible for what. And maybe this answers my question about the title insurance and things like that, but who's preparing the deed, closing attorney fees, real property transfer tax, charges required for the HOA. You've got disclosure fees, buyer title policy. So you see the buyer's paying for the title insurance, and buyer's title examination fee. Let's look at Florida. Florida's going to be different, I would guess. So you've got preparation of the deed is on the buyer. Real property tax. That's a big one. So document stamps, which I believe that's what this is referring to, deed tax, I think is 70 cents per 100. So it can be a really big number. And if we compare that to Georgia, who pays for that? In Georgia, the buyer does. Actually, they don't even, here it is, right here, number 4. Real property transfer tax, buyer pays that. So that's going to be different. And that is more along the lines of what you would see, traditionally in Florida, where the seller pays this doc stamp tax. Those are kind of the big things. If we look again at the buyer's title policy, this is the last one that in Florida, it is somewhat standard practice for the seller to pay for the title policy. So when we look at these total credits, this service credit, you also have to add on these big numbers, the deed tax and the title policy. It could be thousands and thousands of dollars. In fact, on a $500,000 purchase, which that's what this is, the title insurance in Florida could be $3,000, something like that. So that's 3, and then your doc stamp tax is $3,500. So there's $6,500 that the seller is going to have to pay. So I think in summary, these are great deals to have, some sort of knowledge about, to know that this is what the iBuyers are doing, that they are national companies, most of them, the big ones at least, and they are doing a standard form, couple of little tricky things, but then they have a very Georgia specific or Florida specific or Iowa specific addendum that goes along with it. And at the end of the day, you can talk your seller through it. You know generally what the big points are, but you should always direct them to working with an attorney, make sure that they are represented, make sure that they understand the full scope of their deal. And if you're trying to convince them to take your offer, to have you list it instead of them just take the easy option out, they need to be able to compare apples to apples. They need to know, hey, this is $1,000 down. We would normally ask for $5,000 down. So I hope this is helpful. I hope that if you have questions, you reach out to me, and I wish you and your clients the absolute best of luck. And just be prepared for anything. This is kind of a quick, easy way for me to go through a contract, highlight, and most importantly, educate, because I'm not sure how much we're going to be able to negotiate, but we do need to understand it. We need to make sure that the seller knows exactly what they're getting themselves into, and then when they get themselves into, they're not going to be upset or confused. So I hope that's helpful. I wish you the best of luck. Don't hesitate to reach out. Thank you.